Greg, you want to get us started?
Greg, you want to get us started here?
Can you hear me?
Yep, we got you.
Yeah, I can't, I'm having speaker issues here. Give me a minute. You got me?
Yeah, we got you now. I think we got you teed up for your slide here if you want to get going.
All right. Guess I missed the intro there. Morning, folks. I'm Greg Griffiths. I'm going to get us rolling today on our topic of the day. I'm going to start off by talking about some areas of potential liability, and then I'll be handing the ball off to Hilary. So to start, I'm going to talk about failure to comply with certain government regulations that are outlined on the first slide. Hilary's going to step in and talk about issues related to OSHA. Then we're going to pass the baton to Allie to talk about claims that can be brought by employees, and then we'll shift back to claims that can be brought by third parties. And the focus of my presentation at the beginning really relates to government regulations that impact employers that are getting ready to reopen, and some of the potential legal pitfalls that we can fall under. And first, I'm going to talk about some of the government executive orders. Dave, you want to advance the slides, please? Next slide. Oh, shoot. So first, we're going to talk about failure to comply with government executive orders. And the first one is failing to shut down. All right, and if we look at what we've all been facing with, we had a government executive order that came into play that ordered businesses to shut down unless they met the certain criteria of essential workers. And if you didn't shut down what you should have, you face some potential legal liability for that. More recently, we've had the rule relaxed by executive order of Governor Walz that allowed some offices to open and allowed some industrial facilities to open, but they could only open upon adoption of a reopening plan that complied with the regulations set forth by the Department of Health and the Department of Labor and Industry. And so the second sub-point I have in this slide is failure to adopt the reopening plan. And my premise here is if you're going to open and you believe you fall under one of these exceptions, you have to have the reopening plan in place that addresses things like checking on employees' health, dealing with an employee who gets sick, failure to maintain social distancing in the workplace, and different changes to the arrangements in your office. And I'm aware of at least one employer that has had contact from OSHA. Matter of fact, it was yesterday. OSHA was inquiring of them why they opened without having a reopening plan in place. Now, as it happened, the complaint that OSHA received was made by a disgruntled employee, and in fact, the employer did have a reopening plan in place, so there wasn't an issue. But my point is that OSHA is on this, and they've got a hotline that people can call to make complaints about this. So my premise is twofold. One is if you are going to open under one of these exceptions, you have to make sure you have your opening plan in place and be aware that the government regulators are ready to hop on board and chase after employers who aren't complying with this. So, and the other point I would make as well is under these executive orders, someone who opens in violation of the executive order actually commits a crime, and it's a misdemeanor, and you can be, tagged and fined and potentially face jail time in violation of the rules. And I happened to read in the media this morning that there was a employer in one of the states that is in the process of opening. They opened 7 days too early in violation of the executive order in that particular state, and the person was sent to jail for 7 days. So the point is this is serious stuff, and we have to make sure that we comply with these rules. So get your reopening plan in place and make sure that we don't have OSHA chasing you with respect to that. Next slide, please. Now, there's a couple other different things you need to pay attention to. One is government regulatory action that respects failing to comply with Department of Health and CDC guidelines. And the second is failing to comply with FFCRA guidelines. And I'm going to get into that after Hilary talks about OSHA. But in the event that the Department of Health issues regulations, rules, and among them is the directive that you follow CDC guidelines, there is risk that you could have the Department of Labor or the Department of Health or other regulators coming after you as the employer for failing to comply with the relevant guidelines that are issued. So for example, one of the things we're hearing about is Governor Walz issuing the relaxed executive order, and he's suggesting that you have to have this reopening plan in place that complies with Department of Health and some CDC guidelines. You have to do what you say you're going to do. So if you put your reopening plan in place, but then you don't do what you say you're going to do, you're potentially going to face government regulatory action for not complying with Governor Walz's executive order. So my point is, it's not enough to have the reopening plan in place. You have to make sure you have the plan in place, and then you have to follow it. Otherwise, you could have the Department of Labor or OSHA knocking on your door. Now, the FFCRA guidelines I referenced on my last point on this slide relates to the leave laws that were implemented by Congress. And remember, and I'm going to get into the details shortly, but those are the laws that give employees 10 days of sick time and additional time to stay home to care for children whose childcare or school is closed. So just be aware of those FFCRA guidelines. Next slide, please. Now, the next point I make on this slide relates to failing to comply with wage and hour rules. And most of you are generally familiar with the rules that we're talking about, and they're really threefold. One is you have to pay employees for all hours that they work. 2, you have to pay minimum wage. And 3, you have to pay overtime for hours over 40. But my focus is on this slide is going to be with respect to that first point, and that is failing to pay employees for all hours that they work. And this comes into play because many of us have employees that are working remotely. And if they're working remotely, we don't necessarily have a good idea of all the hours that they're actually working. And so there's some risk that an employer is going to not pay an employee for hours that they work. And my basic practice point here, or the takeaway to all of you, is make sure you have some mechanism in place to track the hours that the employees are working. And maybe your computers are set up so that they're actually logging in and logging out. Perhaps you're having them actually fill out a remote timesheet and submitting it. There really isn't guidance for us about how you have to be tracking the time, but the rules require you to track the time, and the rules require that you pay employees for all hours that they work. So make sure you're really tuned into this concept of having a policy in place about how you're going to track employees for all hours that they work. Because there is some risk that in the long run, you could be facing some legal liability for not doing that. And I get asked quite frequently, Greg, how does that happen? Well, it really happens in 2 ways. One, if you have an employee that becomes disgruntled and they file a complaint, or 2, you have OSHA, or the Department of Labor do an audit and somehow find that you're not paying employees for hours that they work. So make sure that you're tuned into this and that you're paying employees for the hours that they're working. Next slide, please. Now, before I go any further, I see a question just popped up about salary employees filling out timesheets. And I will say that if you got an employee that is an exempt employee, meaning they're paid a salary and they meet one of the exemptions from the overtime requirements, the short answer is no. Exempt employees do not have to track their time. So when we're talking about tracking their time, we're typically talking about hourly employees. Otherwise, exempt employees who are paid a salary, you do not have to track those folks' time. Now, the next area of government legal liability relates to Americans with Disabilities Act and discrimination laws. And the ADA, as we refer to it, basically requires you to accommodate workers who have disabilities. And where this comes up is perhaps you're trying to get your workforce back to work, and you have an employee that comes in and makes a request for a reasonable accommodation. Maybe they want to keep working at home. And you have to engage them and find out what the basis of the request is, and then determine whether or not you can accommodate it. And one of the questions I've been getting a lot lately is, Greg, what if I ask an employee to come back to work? What if they tell me they've got a health issue and they don't want to come back to work? Do I have a problem? And the short answer is not every condition is a disability under the law. And if an employee is simply afraid to come back to work, that's not something you have to accommodate. If you have an employee that brings in a medical note from a doctor indicating that they've got a significant health issue, it might be wise to engage them and to determine if you can accommodate them. Otherwise, you could be walking into an ADA claim. And the same thing is true with discrimination claims, but where discrimination claims could be coming in relates to layoffs and return to work decisions. So for example, someone could be raising an issue with respect to why they were laid off or not returned to work. And Allie's going to be getting into this a little bit more later in the presentation, but the point I'm making is if you are considering the wrong reasons, perhaps age of employees, hopefully not race, religion, or disability, but if you're making your decisions to lay off or bring people back for illegal reasons or the wrong reasons, you could be facing government regulatory action for doing that. And so just make sure that you're making your layoff and return to work decisions for legitimate business reasons. And Allie will give you some pointers on how to do that properly later in the presentation. Next slide, please. Now, another point I thought was worth raising is what about workers' compensation? We've been hearing a lot lately about whether employers are going to be sued related to employees getting COVID-19. We've been hearing about whether Congress is going to provide some sort of immunity for that. Hilary's going to be talking about that a little later in the presentation. But I thought it's worth pointing out that workers' comp claims have to be work-related, which means they have to be causally connected to work. And under longstanding law, illnesses are typically excluded for workers' compensation. So this basically means that an employee has to demonstrate that whatever their health condition is causally related to the workplace. And I've been proceeding under the assumption that it's going to be really difficult for an employee who gets COVID-19 to claim that they got it at work. There's so many different places that someone could get, catch this virus that I just don't know how somebody would do that. And illnesses are typically excluded. So, but for some regulatory action, I'm just not seeing a lot of validity to these concerns that employees are going to suddenly be bringing workers' comp claims against employers for getting COVID-19. Could it happen? Sure, it could happen, but based on what we know now, I'm not seeing that. Now, I will point out the last point on this slide, which makes clear that there is a different rule for certain employees, such as first responders and certain healthcare professionals. that the law has been switched with respect to those folks. In other words, if they get sick, it's presumed that they got it at work, and those folks do get workers' compensation. But other than that, I'm not anticipating a huge increase with respect to workers' comp and COVID-19. But obviously, stay tuned to that one. Next slide, please. Hilary, to you.
Thanks, Greg. Yep. Looks like there's some issue with the slide here. There we go. Thanks, Greg. This is Hilary Stonelake-Curtis, and I want to say thank you to everybody for joining us today. And we appreciate the opportunity to be here with you today to present as up-to-date information as we can during this uncertain time. And thanks to Christy and Amanda and everybody at the Winona Chamber for letting us be here today with you guys. So let's talk a little bit more about OSHA, because this is something each of you should be thinking about as you prepare to reopen your business. Most of you know about OSHA and its general workplace requirements like posters or recording injuries and reporting those. But there are additional requirements now due to the COVID-19 crisis. So we'll talk a little bit about those. But first, we need to know what our legal obligation is and what happens if we fail to meet it. The Occupational Safety and Health Act, which is the applicable law, sets forth the legal standard or the duty of care. And they do this in the General Duty Clause, or the GDC. That requires employers to establish a workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm. We already know that exposure to coronavirus is considered a recognized hazard. So now that we know that's a known hazard, we have an obligation to reasonably try to prevent that. If OSHA determines that you failed to meet your duty of care, you could be subject to fines, and an enforcement action under the GDC, or the General Duty Clause, could be taken against you. So how do we prevent that? Next slide, please. Thankfully, OSHA has published guidance on how to meet your obligation, and that guidance can be found on OSHA's website. I strongly recommend you all go to OSHA's website and check that out. There's a ton of information on there. There's a 35-page guide related to making your workplace safe, or helping prevent COVID-19 in the workplace. There are posters on the website that you can print out and put up in your workplace. So again, check out OSHA's website. Broadly speaking, OSHA has taken the position that businesses should follow CDC and Department of Health guidelines. So stay up to date on those resources as well. And again, the CDC website is very good. Has a lot of information, has a lot of published facts that are really helpful, and they seem to update that pretty regularly, so be sure to check that out as well. So aside from that, you're wondering, well, what specific steps am I supposed to take? What am I actually supposed to do? Well, OSHA's defined 4 broad steps that each of you should do, and these are likely applicable to many of you on the phone who are small or medium business size business owners. And these are the 4 measures that you should all be taking. Number 1, develop that preparedness and response plan. Greg talked a little bit about this. There's a link on this slide to the Department of Labor and Industries template for that. And if you haven't already, go on there, check that out, and get that plan in place as soon as you can. Some of these other things are kind of common sense no-brainers, I'll call them, like prepare and implement basic infection prevention measures. Tell your employees to wash their hands. If they're not feeling well, stay home. Cover their coughs and that sort of thing. Policies and procedures for identification and isolation of sick people if it's appropriate for your workplace. Develop and implement and communicate about your workplace flexibilities and protections. This is important because you should be transparent with your employees. Let them know you have a plan. Show it to them. Talk with them about that. And that's another way you can protect yourself from liability claims. Number 1, do all of these things. But then number 2, let your employees know and let them participate. Next slide, please. Some questions we've been getting relate to record keeping requirements under OSHA. So our employee COVID-19's recordable illnesses, yes, if these three elements are met, and this slide is looking a little goofy, at least from my perspective. So the 3 points in the middle there are the three elements. So number one, if you have a confirmed COVID-19 illness, for example, you have a positive test result. If the employee's exposure is work-related, meaning it's more likely than not, for example, there's objective evidence that the employee contracted it at work. For example, if you have a bunch of line workers and they all get sick and there's really no other alternative explanation as to how that happened, and they report it to you, the employer, then that's going to be probably work-related. And if this COVID case involves one or more of the general recording criteria, which is a term of art under OSHA, but generally speaking means your employee has a day away from work or has to seek medical treatment, that sort of thing. So yes, it is a recordable illness if these three are met. But note the bottom note on this slide. OSHA has said, look, we're going to take into consideration your good faith efforts to comply with our requirements in the CDC and the Department of Health. So that's why these are so important, because they are steps you can take to prevent yourself from getting a fine or having an enforcement action taken against you, and just generally to protect you, liability speaking. Next slide, please. Greg, you want to take it here on Families First?
I commented on this a little bit earlier, the Families First Coronavirus Relief Act, and I just thought it'd be worth a couple slides in here as a reference point for you to remind you what the obligations are under these laws. First, 10 days of paid sick leave, up to a max of 5 and 111 per day. And they get this in limited circumstances. There's been a quarantine or isolation order. They've been advised to self-quarantine. Or perhaps the most common one that I've been hearing about is the employee who says, hey, I'm not feeling good. If they're experiencing symptoms and they're seeking a diagnosis, they get 10 days of paid sick leave as well. And there's two other forms paid at a lower rate. One is if you have to care for someone that's been quarantined or isolated, or you've got children under 18 home whose school or childcare is closed. Those folks can get paid sick leave at the lower rate of 2/3 of pay up to a max of $200 per day. Next slide. Now, the other form of this is the expanded FMLA, and this is relatively limited. It only applies to people who have minor children home because their school or child care service is closed due to the public health emergency. So if that's the case, they get a total of 12 weeks. If the first 2 weeks can either be unpaid or they can use the paid sick leave under the prior slide. But otherwise, the 10 weeks must be paid at the 2/3 level up to $200 a day. And one thing to be aware of is, as I was asked this question this morning, can I require employees to use their own paid sick time during the first 2 weeks that are unpaid? And the short answer is no. You can't require employees to use their paid sick time. They can elect to, but otherwise they can leave it on the books. So just bear in mind when we're talking about Families First Coronavirus Relief Act liability, we're really talking about these two things, which is if you don't give them the paid sick leave or you don't give them the expanded FMLA to care for minors who are home because of a school or child care closure, you can face government legal regulatory liability as well as legal liability involving folks who get lawyered up as well. Next slide. Now, I thought it was worth noting that that you shouldn't forget that the FMLA still applies. FMLA applies to larger employers with 50 or more employees, but if you're a larger employer, folks that still get their total of 12 weeks of unpaid leave. Now, I mentioned the expanded FMLA on the prior slide. And don't forget that it's still a total of 12 weeks. So if someone takes their full allotment to stay home to care for kids during the 1-year period, they don't get an additional 12 weeks under standard FMLA. And remember that not every illness is a serious health condition. So if someone comes in and just says, hey, I'm sick, that's not FMLA, that's sick time. An employee who chooses to stay home out of fear, that is not FMLA. So if you have someone that chooses to stay home out of fear, there's a question as to whether, how that's going to impact their job, but that's not paid sick time and that's not FMLA. And the same thing is true with someone who stays home to take care of children. If they don't have a child care closure, if they don't have a school closure, and there's not a child who's sick at home, that is not FMLA. So don't forget that the FMLA is still in play if you're a larger employer. Otherwise, the 2 forms I mentioned under the FFCRA slides, those apply to all employers, not just larger ones of 50 or more employees. Next slide. Okay, Allie, off to you.
Thanks, Greg. So my plan with these slides is to provide tips and best practices on how to avoid employee liability. If you guys have any questions along the way, feel free to use that chat function, and I think Greg's going to be monitoring the chat feature for any questions. So this first slide deals with when you have to make the decision in reopening your business regarding layoffs and furloughs. And this speaks to liability under the ADA and anti-discrimination laws that Greg was talking about earlier. So we really recommend that an employer be able to answer the following questions to avoid liability under the ADA and any type of anti-discrimination laws. So the first question to ask yourself is, why is this action needed? In other words, can you point to a legitimate business reason for this layoff or furlough? Second, what criteria are you going to use as to who gets laid off or furloughed? This kind of brings up 2 main reasons or points for this question, but the first is you want to make sure that you're deploying the same criteria in each scenario. And second, you want to ensure that your criteria is sound. In other words, are you relying on mistakenly relying on biases or stereotypes? For example, Greg pointed out you don't want to use the criteria of age or disability as your criteria. Instead, criteria would be something along the lines of, I'm going to bring back the highest performers, or I'm going to bring back the most versatile employees. And then last, you should be able to answer the question, why was each employee laid off or furloughed? So really, you're looking at the specific reason why this employee meets the criteria that we talked about in that second question. And the underlying reason for all of this is that you want to make sure that your employees don't feel like they were pushed to the end of the line or out of the line due to a particular or a protected characteristic. And you can point to a well-reasoned analysis as to the criteria that you're using for layoffs and furloughs, and that you're able to point to a legitimate business reason. Next slide. So, on the flip side, you're also going to be transitioning employees to come back to the physical workplace. And an employer will want to know the answers to the following questions. Why are you ready to bring people back? Again, what criteria are you going to use? And third, why was each employee included? So I'm going to walk through what your responses to these questions might be. So the first, let's say you're bringing people back because business has picked back up, and like Greg and Hilary reiterated, you have your preparedness plan in place and you're allowed to open under the governor's executive orders. So you're ready to bring people back. Third or second, what criteria are you going to use? So maybe the criteria you're going to use is you're going to bring back the most versatile employees back first. So, and then third, why was each employee included? So look at each employee. Employee X, right? Employee Joe Smith is the most versatile because insert your response. So Are they trained in multiple departments? Are they trained on all the software platforms? Whatever your reason is to show that it meets your criteria, and your criteria here being the most versatile employee. On the flip side, and kind of talking about the previous slide, is if an older worker does not get brought back, as an example, are you able to point to a legitimate business reason why they weren't brought back? Here, you didn't bring back this employee because they are not the most versatile employee. So the underlying premise for but these two slides are with layoffs, furloughs, and bringing people back, it's important to ask yourself these questions ahead of time to avoid any future liability from employee claims. Next slide. So another liability challenge that we've been seeing is in the realm of retaliation and whistleblower claims. So for example, this would be in the form of an employee claiming they were disciplined or discharged for citing a health and safety concern. And I think there's been a couple news-related stories related to a whistleblower claim and possibly Trader Joe's. So it's definitely a pertinent topic for employers right now. But there's two important points to remember here. The first is it's unlawful to retaliate against an employee for asserting his or her rights. For example, you can't discharge an employee for requesting time off to care for a child whose child's school has closed, right? Because under FFCRA, which Greg was talking about earlier, an employee has certain rights to request time off. You certainly can make sure that that request is legitimate, but you can't discipline or discharge an employee for asserting his or her rights. The second point, it's unlawful to retaliate against employees who assert good faith complaints of laws or rules. So in this realm, with lots of health and safety concerns coming up nowadays with the COVID-19 crisis, you should encourage employees to report health and safety concerns. We recommend confirming and updating the company's procedures for responding to and addressing these concerns. And it's really important to also document your response to these concerns. You really want to show that you gave multiple avenues to report these concerns and that you also addressed each concern. If you also find yourself in the realm of having an independent reason to justify a termination of an employee who also just raised a concern, I would recommend that you walk through these questions. Do you have a legitimate reason? Can you go to the previous slides and point out a legitimate reason for this termination? Is this reason properly documented? Is it consistent with your company's policies? And can you say that other employees who engaged in similar conduct but didn't raise a concern, are they given the same disciplinary action? It's just important to walk through these different steps to make sure you can avoid liability under any type of retaliation or whistleblower claim. Next slide. All right, another area where there could be liability would be in wage and hour. And I'm not gonna spend much time on this because Greg already went over the liability and the risks involved with these claims. But again, just to drive home the point, it's important to remember that all employees who perform work for an employer, even while out of office, must be paid. And we would recommend putting in some type of record keeping system. An easy one, would be entering having employees enter time daily and emailing that record keeping to a manager to ensure that everything is properly recorded. And the last thing I would mention here is to consider reiterating to employees to record all hours worked contemporaneously, and then what your expectations are for tracking breaks and overtime. Okay, next slide. So as Hilary and Greg mentioned, there are a bunch of new guidelines, either it be under the CDC, OSHA, wherever, that require employee health screening. And in addition, monitoring of employees' health. So clearly, you know, taking employees' temperatures, etc., it's really a new concept for employers. So with this comes heightened risks of privacy complaints. A couple of reminders and best practices to keep these risks at bay are: remember to maintain the privacy of employee records, and remember to maintain the privacy of what you learn about employee health information. For example, let's say an employee comes to you disclosing that they have a medical condition which they believe, you know, is a heightened risk if they were to contract COVID. Okay, what you know, that is confidential information, so you need to make sure that you're going through your normal processes and maintaining the confidentiality of that medical condition. And then last, remember to limit the disclosure of that medical condition or confidential information to management employees who need to know. So under the ADA, it's important to remember that employee medical information, including contracting the coronavirus, must be kept confidential and can only be shared. So an example of this is, let's say you have an employee that contracts COVID-19. What can you do as an employer? So you can send a general communication or notice reporting to your employees that there has been a suspected or confirmed case in the workplace. That's okay. However, where you would expose yourself to liability would be if you were to share the identity of the employee who contracted the virus. That would be a violation of the employee's privacy and would potentially expose you to liability under state privacy laws. So, you know, that was just a general overview of best practices to avoid any employee liability, either a private claim from an employee or via a state department that has received a complaint from an employee. There's also liability in the form of third-party claims, which I believe is next slide, and Hilary's going to walk us through that type of potential liability. Hilary?
Thanks, Allie. Yeah, and when we're talking about third parties, we're talking about customers of your business or members of the public. And I saw, before I forget here, a question in the question and answer section over here that says, what's the outlook on public events and liability related to COVID? Is there event liability coverage that would include pandemic circumstances? And I'll address this right off here. So this is the third type of third-party liability that we are talking about. You know, is in terms of the outlook on public events and liability, I think it's going to look a lot different than what we're used to now. For example, if you're hosting a beer garden or an outdoor concert, I think for a while at least, either we won't be having those, or when we are able to do that, when the governor fully opens the state, it's probably going to look a lot different. Either you'll have to take some social distancing measures, or limit the number of people, that sort of thing. So I'm not sure exactly what it will look like, but certainly that is an area that would raise some liability concerns, and I'll talk more specifically about what those concerns might be. With respect to liability coverage, a lot of policies, I think, have an exclusion for pandemic coverage. And so my advice would be to talk with your insurer, review that policy, and generally speaking, if the insurer can include an exclusion for something, we're probably going to see that. So anyway, I would say talk with your insurer about that and read your policy carefully. And then Greg and Allie, if you wanted to jump in on that, or if you think I missed something, just feel free to jump in. But coming back to third-party things, so this could be somebody coming into your business, later getting sick, and then blaming you for exposing them when they came into your shop, or again, somebody at one of your events. And you're going to see those claims probably come in the form of a negligence claim. In other words, you, owner, business owner, had an obligation to keep me safe and to keep me healthy when I was in your store. You failed to do that, and now I've been damaged. That's going to be a negligence claim. And what would bolster that claim is if they can say, you had no plan in place. You didn't have your preparedness plan. You didn't screen people coming in, and you didn't follow CDC guidelines or industry standards, whatever they may be. So those are the kinds of things that'll set you up for a third-party liability claim. Next slide, please. So how can we avoid some of these? Well, we've beat on this today. Adopt and enforce your policies. Are you going to screen all your employees coming in every day, or your customers? If they refuse, are you going to remove them? Have those policies in place. Know what your plan is and execute. And don't be discriminatory in how you execute it. If it's one, it's everybody. Follow your plan. Comply with the executive orders, the CDC guidelines, and you guys follow the best practices for your industry, because you're in the position to know best or what is best for your particular industry. At the bottom of that slide, you'll see a link to the Minnesota Deeds website. Last week, they announced a digital tracker that essentially allows businesses to enter some non-personal health information to help that business make a determination about whether someone should enter their facility or not. So check that out, see if that might be something that would work well for your business. Next slide, please. Limits on potential liability. Are we going to see any? We don't know. And when I'm talking about limits on potential liability, I'm referencing what's going to happen either in Congress or at the state level. If you've seen the news at all lately, you've heard about the fight that's going on at Congress with respect to CARES 2, or the next round of funding. On the one hand, you have the Republicans saying, we're not going to agree to anything unless there's broad liability protection for these businesses. On the other hand, you have the Democrats saying, no, you just want this as a chance to enact tort reform policies. So it's shaping up to be a political battle. It already is, we know that. So, generally speaking, I don't know if or what will ultimately come through. We think maybe it'll be some sort of middle of the road where, absent willful or reckless conduct, you probably won't be liable, especially if you're doing everything the CDC tells you to do. You're following OSHA guidelines, you're obeying executive orders, that sort of thing. And states are now looking at adopting legislation in this regard. I saw this morning, New Jersey has introduced some legislation related to its work comp system that generally says, let's provide a presumption of compensability for those essential workers who get sick. So those workers who have been in essential businesses. In other words, if there's an essential worker who gets sick, they'll be presumed to have gotten COVID-19 on the job and then qualify for work comp. That I don't think has gone through yet, but it is a potential and one avenue that a state could take to enforce liability protections. Next slide, please. A quick note about PP loan forgiveness and rehiring, because we're getting a lot of questions about PPP loan forgiveness, and we're following this very, very closely. On Monday, I think it was, the SBA and the Treasury Department issued additional guidance regarding loan forgiveness and rehiring of employees. And you'll see a link at the top of this slide to those frequently asked questions. But what's I wanted to note today was the question 40 that came out. Generally, employers and borrowers want to know, will my loan forgiveness amount be affected if I want to bring an employee back, but they refuse to come back? The answer is no, which makes sense. If the employer makes a good faith written offer to rehire somebody on the same conditions, for example, the same salary, the same hours, that sort of thing as before, and the employee's rejection is documented. Now, there's no guidance, of course, on what that documentation has to be, but safe to say it's got to be somehow, probably in writing, you know, whether it's an email confirmation or somebody initials a box on a letter, whatever the case might be. But I will also note the guidance says employees who reject these rehire offers may be forfeiting eligibility for UI benefits or unemployment compensation. So we are advising clients, you know, you might want to think about sending a recall to work notice, a letter to your furloughed employees that say, hey, good news, we're ready to bring you back. Here's the date we expect you to show up. Then you'll be back at the same rate of pay, the same benefits. And by the way, if you refuse to come back, that's going to be considered a resignation, and your unemployment benefits might be affected by that. Because what we're seeing is a lot of employees who don't want to come back to work because they're receiving the $600 plus the regular unemployment insurance. And so employers are finding it difficult to bring people back. So that recall notice might work for some of you, it might not work for others, but it's something to think about, and we can get you more information on that if you need it. Next slide, please. Greg, you want to talk about some facts?
Sure. I think I'll hop in now and comment on a couple FAQs that kind of cover a variety of the issues that we're talking about. One of the things that I've heard is, you know, can I ask an employee to stay home or leave work if they exhibit symptoms of COVID-19 or the flu? Short answer is, you bet you can. There have been some limitations historically, but in the environment we're in right now, the guidance from the EEOC and other regulators is that you're free to direct employees to stay home if they are exhibiting symptoms. Another question we've been seeing a lot, and many of you have probably seen in the media as well, is can you take employee temperatures at work to determine whether they might be infected? And the answer is yes, you can. One of the best practices, so to speak, that we've been seeing with respect to these return to work plans is guidance that employers should take steps to take employees' temperatures on the way into work. Are you required to do that? You are not required to do it, but it's a practice that we're going to be hearing more about. The third point in this slide is another question I've been getting asked is, how do I take temperatures? How do I screen employees and customers? And the guidance on taking temperatures is that you should have a protocol for doing it. You should maintain social distancing while you're doing it. The person taking the temperature should be provided with proper equipment, PPE, as they say, to make sure that they can do it safely. And I would argue that there's a lot of employers out there that are probably not prepared to take the steps necessary to take temperatures. And another tool that we've been hearing about is asking employees to take their own temperatures before they leave home. Use written questionnaires of employees and customers and other people coming into your workplaces. And that's certainly permissible as well, as long as the questions are limited to those you really need to know for purposes of what you're seeking. So in other words, do you have any symptoms? Have you been exposed? Have anyone around you have symptoms or been exposed? Questions of that sort. Another frequently asked question we've been getting is, what do I do if an employee tests positive? And first and foremost, have them leave work if they are at work, and make sure they stay home if they are home. And the guidance from the CDC at this point is that they should stay home at least 10 days after their symptoms resolve in the event of a positive test. In the event of a negative test, the guidance is that employees should still be expected to stay away from work for 72 hours after resolution of all symptoms and a negative test. What about this question? What should I do if an employee has a suspected but unconfirmed test? Obviously, don't let them come to work. And I had a question posed to me lately, Greg, what if I have an employee that refuses to be tested? Don't let them come to work until you get a resolution of it. And at the very least, you don't let them come to work until the situation resolves itself. But at the very least, 10 days in the event there's a positive, or if it's negative, 72 hours after resolution of symptoms. Finally, on the slide, can you require an employee to notify the company if they've been exposed and have symptoms or have a positive test? And the answer is yes. You can have a policy in place that makes clear that your expectation is that employees notify you in the event any of those things occurred. The bottom line is you want to encourage your employees to bring these issues forward when they have issues come up. Next slide, please. Now, this has been touched on earlier in the presentation, but what if you have the employee doesn't want to come back to work? And trying to keep it simple is that if your employees don't have a legitimate reason for not wanting to come back to work, it's the equivalent of a resignation. And you can notify them that you want them to come back, and if they don't, it's going to be considered, in effect, a resignation from employment. You can certainly notify them that it could impact their unemployment, because one of the required elements of unemployment is that the employee has to remain ready, willing, and able to come back to work. And if they refuse, that can disqualify them for unemployment. But I think the best practice at this point is, if you're really trying to verify that an employee isn't coming back and they're refusing to come back, you should send them a written notice of what your expectations are. Now, another question that's been popped up in that situation too is, Greg, what if I have an employee that doesn't want to come back to work because they have an underlying health issue? And that's really a different situation. In that situation, you really have to engage the employee to determine if there's some way to accommodate them. For example, can you allow them to work from home? Can you provide them with some kind of a private workspace? Can you provide them with a position that would allow them to have social distancing from employees? And each case is going to be unique, but you do need to at least engage the employee to determine what the issue is. But at the end of the day, if they have an underlying health condition that you are not able to accommodate, it could potentially put that employee's health at risk. They might qualify for FMLA. It's going to, depending on the circumstances, that might require you to keep a position open, but it's a case-by-case analysis. But the main point I'm trying to make here is, if you have an employee that comes forward with an underlying health condition, you do need to engage that employee to see if there's something you could do to help them return to work. Next slide. That is the end of our presentation. If there's any questions, please feel free to put them in the Q&As or the chat, and we'll be happy to respond to them. Otherwise, we appreciate the opportunity to present to all of you. Thank you for your time, and stay safe.
Thank you so much, Greg, Allison, and Hilary. We appreciate all of your expertise at Dunlap Seeger, and we appreciate you sharing that. For those of you that are still on, we do have a couple other workshops that are upcoming. Tomorrow, best practices for working from home. If you haven't registered, please reach out to us to register for that, as well as mental health in the workplace next week. And we will be partnering with Dunlap Seeger in the future for another webinar once guidance is available to them on maximizing your PPP forgiveness. So watch for that as well. Again, thank you to the team of Dunlap Seeger, and thank you all for attending.
Thanks, everybody.
Thank you.